Says People versus Rosalind Ray Keenan. The allegation is that on or about May 16th in the village of White Pigeon, she did resist and obstruct a police officer and drive with a suspended driver's license. Resisting and obstructing is a felony now. It's punishable by up to 2 years imprisonment. And driving suspended as a traffic matter, punishable by up to 93 days in jail and a fine of up to $500. Carries 2 points on your driving record and requires that your license be suspended. Someone who is identified as Rosalind Keenan is present, and she wanted to explain more about that. We'll give her a chance to do that, but Prosecuting Attorney David Marvin is here, and he's representing the state. So let me ask you again, are you Rosalind Ray Keenan?
I'm here as sui juris in propria persona, Rosalind Ray family of Keenan, beneficiary. Is this on record?
Yes, everything has to be on the record, so it's all being recorded.
So what does this video and the Karen from it have in common? They both get released at the same time, today. The narrator welcomes viewers with his usual confidence, setting the tone for another wild courtroom encounter. He reminds everyone of his past live stream comment about the Venn diagram, where sovereign citizens and Karens meet at the center, that chaotic overlap we've all come to enjoy. This video is exactly that. A sovereign citizen Karen who just can't keep quiet. Her arrogance will soon meet the immovable patience of Judge Middleton. It's courtroom drama meets comedy, a legal meltdown waiting to happen. And as always, the narrator promises one thing: this won't end well for her. So let's begin.
Okay, I'm here on the special appearance, and I'm a free woman on the land. I'm here under fraud, menace, and duress. I am the private woman, Rosalind-Ray Colon.
All right.
Keenan. The all capital mentioned name is the only appellation given to me. Anytime I autograph is to be done in a certain manner that I have here, or it's forgery. Could you do this for the judge, please? That's my name. Thank you.
All right, I'll accept this.
Thank you.
All right, so I think we have the right person here. When she signed her bond, she signed it as Rosalind Ray Keenan beneficiary with quick bail bonds. All right, now we've got another issue. This is a felony charge. The first one is. The second one is under the Motor Vehicle Code. And it requires that we have a preliminary examination, or it requires that you're entitled to a preliminary examination. We had a pre-exam conference last week, and you expressed at that time that you did not wish to have an attorney. You're here with you this morning without an attorney, and we'll address that in a moment. You've been talking with Mr. Marvin. You have an absolute right to represent yourself. I normally don't recommend it.
The hearing opens with Judge Middleton calling the case People versus Rosalind Ray Keenan. His tone is calm, deliberate, and filled with quiet authority. He reads through the charges: resisting and obstructing an officer, a felony carrying up to 2 years in prison, and driving on a suspended license, punishable by 93 days in jail and a $500 fine. He even explains that it adds points to her driving record and keeps her suspension active. The courtroom stays silent as the judge explains her rights and the possible penalties. Everyone seems to understand what's going on, except Rosalind. The stage is set, the law is clear, but this defendant isn't living in reality. Her sovereign fantasies are about to collide with legal truth.
Mr. Marvin, is there a plea offer here?
There is, and I'll tell you about that. But I wanted to mention that this is, I believe, the third time we've sat down And so this is dragged out a bit, but only because she's not represented. And in these 3 separate meetings and adjournments, the court has allowed those, and I appreciate it. I have spent a lot of time with her and her son, who's here. He's always been here, and they're very honest and they're good intended.
Thank you.
And I think that we've come to a resolution that I believe is fair. I've offered, I'm going to state it for the record, and only time will tell if she's going to accept it, in hopefully 2 seconds. But what I would do is offer an attempt resisting and obstructing and dismiss count 2. And I would ask that the court set this for sentencing at a later date, and I'd ask for 6 months. And if by that time there's no other incidents with law enforcement or any other reason to continue, I would dismiss this, or at any time before that if I felt that it was necessary. And again, after working with her, I don't think this is the kind of thing that should be, I would hate to see this upstairs as her first felony. I think that she's interested in a way of life that she's honestly trying to understand, but I think that partly to assist her.
When the judge asks if she is Rosalind Ray Keenan, she confidently replies with her full sovereign title, Rosalind Ray family of Keenan, beneficiary. The room stiffens as she begins her bizarre monologue about being a free woman on the land. She claims she's under fraud, menace, and duress, and insists that any signature not written her way counts as forgery. The judge listens with restrained patience, realizing quickly that logic won't win this one. Her phrases sound rehearsed, as if copied straight from a sovereign citizen handbook. The audience watches in disbelief, torn between laughter and frustration. The judge keeps calm, but his eyes say it all. Here we go again.
I've kind of hatched this plan, and I've offered that. I have the feeling she's going to take it today, but if not, I've got my officer and we're ready for a prelim.
He's offering to reduce the driving suspended charge. And he is offering to dismiss the felony charge and reduce it to a charge called attempted resisting obstructing a police officer. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Do you understand that charge?
No, I don't understand the nature and the cause of the
All right,
charge.
Mr. Marvin, let's just do a prelim. I'm not gonna tap dance with her. You may be more sympathetic about this flat earth nonsense than I am. But if I'm gonna have to argue about everything from who she is to what the charge is, it'd be easier to just put on the prelim. From the affidavit of probable cause, her conduct was outrageous with a capital O. And so I'll give you one more opportunity, Ms. Keenan. Mr. Marvin is agreeing to dismiss the driving suspended charge. The record shows your license is suspended from Indiana.
Judge Middleton quietly reviews her bond paperwork and points out that she signed it herself. Rosalind Ray Keenan, beneficiary. It's ironic proof that she is, in fact, the same person she pretends not to be. The judge moves on to discuss the upcoming hearing, but she interrupts again, trying to correct him on imaginary technicalities. He lets out a small sigh, knowing this hearing will take twice as long as it should. The prosecutor glances at her son in the gallery, who seems just as convinced by the nonsense. The court reporter barely keeps up as she throws around more meaningless phrases about jurisdiction. Still, the judge holds his composure. He's dealt with plenty of these self-taught law experts before, and they all end the same way.
And you don't have a valid Michigan license. That's a benefit. It won't affect your driving privileges.
Excuse me? What'd you say about the,
It's a benefit. And
no, before that about the license?
he's dismissing it. And it won't affect your driving privileges here or Michigan or Indiana if he dismisses that. So he's offering to dismiss it. And that's a benefit. He is offering to reduce the felony charge to a misdemeanor. And that's attempted resisting and obstructing a police officer. If you wish to do that, we can pursue it now. If you don't, we can take testimony. The officer's been waiting here for 3 hours. What would you like to do?
Are you asking me to take a plea?
I'm asking you if you're willing to accept the prosecutor's plea offer.
Well, I don't understand that.
Mr. Marvin, let's
Explain
just
it.
put
I'm not
on a
playing
prelim.
games. I'm serious.
You are playing games, and first of all, you
I'm trying
don't.
to advance to
All right,
what I'm
stop.
here
You don't
for.
interrupt the judge, whether you're a flat earther or
I'm
not.
not flat earth,
Or
sir.
this crazy stuff you're saying. I've got very little patience for it. You don't have an attorney, which concerns me, because these charges could result in your incarceration. I will appoint an attorney for you. All you got to do is tell me. But you also have the absolute right to represent yourself. So
The prosecutor, David Marvin, steps forward, his voice calm and composed. He explains that this case has been delayed multiple times because Rosalind refuses to hire an attorney. Despite that, he speaks respectfully of her and her son, saying they seem honest but misinformed. He outlines a generous plea offer that could spare her from serious consequences. The judge listens intently, hopeful this could end smoothly. The prosecutor's tone is patient, maybe too patient, as he tries to make her understand the opportunity she's being given. But you can already tell she's not going to take it. Her face says it all. She's more focused on her made-up legal theories than her actual freedom. And in court, delusion always comes with a price.
do you wish to represent yourself, or would you like me to get an attorney to assist you with
It's
this?
my right to appear for myself.
It is.
I don't think it would be a violation of your oath of office
To do what?
to if you did your duty under the Constitution, because I'm seeking legal intent, not advice.
Well, do
And
you
I-
want me to appoint an attorney for you? Would you like to represent yourself?
So may I ask, what jurisdiction is this, civil or criminal?
This is a criminal case, which points out the fact that you could use a lawyer if you can't tell the difference between a civil and a criminal case. Jail, in this case, for up to 2 years. In a civil case, there's no possibility of jail. It's usually over money damages or other types of non-jail relief, like other types of non-jail relief. So yes, this is a criminal case.
Well, thank you. So, you said the record is on.
Yes.
Could the record of the court show that this is a criminal action? And my next question is, I know that the Constitution grants.
The narrator breaks it down for the audience. This is one of the sweetest deals you'll ever hear. The prosecutor offers to drop her felony to a misdemeanor, dismiss the other charge, and wipe everything clean after 6 months if she stays out of trouble. Even Judge Middleton calls it generous. But instead of saying thank you, she acts confused, claiming she doesn't understand the nature and cause of the charge. The judge repeats himself with calm precision, but her defiance only grows louder. You can feel the tension rising as patience drains from the room. The prosecutor's offer, a lifeline, is slipping through her hands. The judge glances down, realizing this is about to take a hard left turn into chaos.
The court two types of criminal jurisdictions. One is criminal jurisdiction under common law, and the other is criminal jurisdiction under admiralty or military tribunal venue under Article 1, Section 8, Clause 17 of the Constitution. Under which of these two jurisdictions is the court intending to try me?
This is statutory jurisdiction of the law of the state of Michigan. It's not any of those things. including the wacky admiralty clause people try to invoke. This is criminal jurisdiction authorized by the state legislature here in the state of Michigan.
Thank you. Well, please let the record of the court show that the court intends to conduct a criminal action against me under a statutory jurisdiction. But that makes me wonder, I have never heard of criminal action under statutory jurisdiction, and there is no such jurisdiction established in the Constitution, and I will be able to proceed if you can show me where I can find the published rules of civil procedures under a statutory jurisdiction and where this nature, cause, and jurisdiction exists. It is crucial that I have the published rules of procedure so that I can conduct a fair defense and fair trial. Otherwise, this needs to be dismissed, and I would like it in writing, please.
When asked if she'll accept the plea, she fires back with, "Are you asking me to take a plea?" The judge nods, explaining carefully, but she interrupts again. Every question turns into an argument about definitions, law, and sovereign authority. The judge warns her not to interrupt. She ignores it. The narrator mocks her absurdity, comparing her to a flat earther refusing to accept gravity. Her tone grows more defensive, more self-righteous, as if words alone could erase evidence. Judge Middleton's patience finally cracks. His tone sharpens, his words carry weight. "You're playing games," he says flatly. The courtroom atmosphere shifts. It's no longer about comedy, it's about control. And she's losing it fast.
Thank you. It's not
Thank
civil
you.
procedure, it's criminal procedure. And the defendant doesn't come up and show, "Court, tell me why I get to do this." You've been charged under the criminal statutes of the state of Michigan, and I've just advised you of that on the record. I'm just trying to establish at this point whether you want to represent yourself or not. As I mentioned, the conduct in here in the affidavit or the bond information report is outrageous with a capital O. And you could very well go to jail for a substantial period of time. Mr. Marvin was trying to extend to you an opportunity to avoid that option, but you're wasting all of our time with this stuff that doesn't have any legal merit. I'm offering to give you an attorney who can actually argue any legal merit or advise you or assist you in this regard. But we've had some White Pigeon police officers here on overtime for several hours. They're still waiting for you to decide what you wish to do. I haven't even gone over the first of all, we had to establish who you were. That took much more time than it deserved. Secondly, I'm trying to determine whether you wish to have an attorney or not. Again, you do have the right to represent yourself. You wish to, but you've exhibited to me that you don't understand the law, and you're at risk of being incarcerated for this conduct. So to further comment on Mr. Marvin's offer, if you pled to the charge of attempted resisting and obstructing a police officer, he offered to defer the sentence for 6 months, and if there were no further problems, to dismiss it, which is...
The judge tries again to explain that this is a criminal case under Michigan law. But Roslyn insists on talking about admiralty law, constitutional clauses, and military tribunals. She throws out terms she doesn't understand, hoping to sound educated. The judge's tone hardens. This is statutory jurisdiction, criminal law. She shakes her head in disbelief, convinced she's found a loophole in reality. The narrator cuts in, mocking her Google degree in nonsense. Still, the judge stays calm, explaining that her logic doesn't exist in any law book. Every word she says digs her hole deeper. What could have been a simple misdemeanor is turning into a courtroom disaster of her own making.
Very generous based on the police report, bond information that I came with the file. what would you like to do here today? Do you wish to represent yourself?
Thank you. I do. I know I can peer for myself. I'm competent and I am confident. Okay?
All right.
So
The next question is, are you
Please.
willing to accept Mr. Marvin's plea offer to plead to the misdemeanor charge?
I wasn't completed with what I wanted to say to you, please.
Okay.
May I? Thank you. So I wanted to say that I don't believe it's a violation of your oath of office if you did your duty under the Constitution, because I'm seeking legal intent. Okay, so I have the right to peer for myself. In order to intelligently defend myself, I have to know the jurisdiction this court is operating under, because the rules of civil procedure under common law jurisdiction are very different from the rules of civil procedure
All right,
under
stop.
admiralty or military
Stop.
tribunal venue.
Stop, stop, stop. We went through this before.
I know.
This is not civil
It's the
procedure.
Sixth Amendment grants me the right to know the jurisdiction being applied,
And I told you what it was.
and it gives you the duty.
All right, stop.
Judge Middleton gives her one final chance: take the deal or request a lawyer. She repeats the same sovereign script. I seek legal intent, not advice. He tries to reason, but she keeps cutting him off mid-sentence. That's when the warning drops. If you interrupt me again, I'll hold you in contempt. 1 second later, she interrupts. The gavel comes down, and just like that, she's going to jail. The judge orders 24 hours in custody so she can think about respect. The narrator can't help but laugh at the irony. She claimed to be free on the land, yet now she's confined behind bars. The courtroom sighs in relief as the bailiffs escort her out, and order is finally restored.
If you interrupt me one more time, I'm going to find you in contempt and you're going to go to jail. And
Objection, please.
all right, please.
Please.
We're going
sir,
to talk
may
about
I?
this
The
tomorrow
contempt.
at 3:00. I find that you're in contempt.
I
You're
do
going
not
to
wish to
jail
be
right
held in
now,
contempt,
and we
sir.
will. Well, you have been.
I'm
This
simply
matter
trying
is
to
adjourned until
exercise
tomorrow
my
at
Sixth
3
Amendment
o'clock.
rights, please.
So you can think about
And
it
we can go
overnight in
forward
jail.
with this right now, please.
No, you're going to
I do
jail
not
for
wish to be in
24 hours.
contempt.
I know you don't wish to go to jail, but you certainly
I
have
will
earned it.
continue with this if you'll please let me finish.
We'll talk about it tomorrow at 3:00, and you will be more respectful to the court.
I
You
can
will speak.
provide the
You will not interrupt the
citations.
court. Your citations are meaningless.
I'm sorry I
So you
interrupted
can
you. If you
go
wanna
with the
continue-
officer. I don't want to argue about it. Take
I'm
her
not
out of here. We
arguing.
will address this tomorrow at 3:00.
Yeah, I don't know what's going on, and I don't think this was a fair trial,
We haven't had a trial yet.
a fair preliminary.
We didn't even get there yet.
I'll be more than happy to. She's going into custody for contempt.
Let's go this way.
As Rosalind is taken away, her son stands up to speak. He tries to defend her, saying it was a misunderstanding, but the judge quickly shuts him down. If you're advising her, you're not helping, he warns firmly. He reminds everyone that she was offered an incredible deal and threw it away to argue imaginary law. The narrator calls it cold-blooded but necessary, a perfect example of how judges should handle sovereign citizen nonsense. Justice was patient but firm. As the outro music plays, the narrator reveals the punchline. She's being released from jail the same day this video goes live. The message is clear: you can't talk your way out of reality. And with that, Team Skeptic signs off. I'm out.